Have you ever felt completely powerless in a financial dispute? You know the feeling. Maybe you paid for a service that was never finished, or you're fighting a battle over money that is absolutely rightfully yours. But then you think about hiring a lawyer, and it just seems way more expensive than the money you lost in the first place. Well, you are not alone in feeling this way. Welcome to This Explainer, where we're going to demystify the legal system and give you a step-by-step masterclass on navigating Maine's small claims courts.
Okay, let's dive right into this. If you're dealing with a contractor who vanished halfway through a kitchen remodel, or a landlord who is suddenly ghosting every single call about your security deposit, this explainer is built specifically for you. And honestly, the most empowering thing you can realize today is that you do not need an expensive legal team to get your money back. Maine's small claims system is literally designed for everyday people to represent themselves and find justice efficiently. Here is a quick look at our procedural roadmap for today. We'll be walking through 1. Small claims basics. 2. Preparing and filing. 3. Serving the defendant. 4. Court prep and hearing. 5. Post-judgment actions. And finally, 6. Resources and our disclaimer.
Let's start with Section 1, Small Claims Basics. What and who exactly are we talking about here? Now, what's absolutely crucial to know right out of the gate is the financial limit. If you looked at Maine small claims law a few years ago, you probably saw a cap of $6,000. But as of January 1st, 2026, the Maine legislature enacted a huge reform, officially raising that jurisdictional ceiling to $10,000. This is a massive shift, guys. It means a much wider variety of commercial, consumer, and tort claims can now be resolved through this cost-effective, informal system without you ever needing to step foot inside the much more complex, regular civil courts.
So what exactly counts as a valid small claim? It's generally all about money or personal property. We're looking at things like unpaid debts for goods or services, getting a refund for heavily unsatisfactory goods from a business that just refuses to make it right, unreturned security deposits without any real justification, or damage to your personal property. Now, it's just as important to know what does not belong here. You cannot use small claims court to settle real estate title disputes, and there is absolutely no bringing personal injury suits against a city or town in this specific court.
And that brings us to the core philosophy of this entire system, pro se. That's just a fancy legal term that simply means representing yourself. Maine's small claims system deliberately strips away the prohibitive, crazy costs of regular litigation. It's meant to be simple, speedy, and totally informal. The strict, intimidating rules of pleading and evidence, they're relaxed here. Because it's designed to be streamlined, there are no juries allowed in these proceedings. A judge will hear your case directly and make the final decision. Moving right along to Section 2, preparing and filing. Let's talk about getting it on paper. Hold on, before you rush to file that paperwork, take a breath and consider your pre-filing options. Court takes a lot of time and public resources. Can you possibly settle this out of court first? Seriously, reaching a written signed agreement halfway can save everyone massive headaches. If you're dealing with a business, the Maine Attorney General actually offers a fantastic, totally free consumer mediation service. A consumer specialist can often step in to help resolve the dispute or give you practical advice before you ever have to fork over a court filing fee.
So, the crucial point is, if mediation fails and you absolutely must proceed, your very first formal step is filling out Form SC-001, which is the statement of claim. You just need to write a short, plain statement of the facts. Basically, why do they owe you money? Now, pay close attention to this part. You must use the defendant's precise legal name. If you're suing an LLC, you name the LLC and its registered agent, not just some random employee you spoke to on the phone. Once that's filled out, you attach copies, and please, never the originals, of your evidence, and prepare to pay the filing fee.
Let's break down exactly what those fees look like in Maine's District Court. If your claim is up to $4,500, the standard fee is $50. If your claim is between that and the new $10,000 maximum, the fee jumps up to $120. However, remember that the system is designed to be accessible. If you genuinely cannot afford this fee, you aren't out of luck. You can submit an application to proceed without payment of fees, that's Form CV-067, along with a financial affidavit to request a complete fee waiver.
Section 3, Serving the Defendant. This is all about giving official notice.
In Maine, you have a couple of primary methods to legally notify the person or business that they're being sued. The first is Form SC-005, an acknowledgement of service, which you can just send via standard mail. This costs absolutely nothing, but there's a catch. It relies on the defendant actually being cooperative enough to sign and return it. If you want a much more guaranteed, hands-off approach, you can use Form SC-006. For a very affordable $15 fee, you submit this affidavit and request for service, and the court clerk will just handle serving the papers for you. Honestly, this is highly recommended for everyday folks who don't want to mess around with hiring process servers. Now, once the defendant is successfully served, a very strict countdown begins. I call this the 20-day rule. You have exactly 20 days from the moment service is completed to mail or deliver the original SCR-001 claim form, your hard evidence of that service, and your filing fee directly to the appropriate district court. Do not miss this deadline. If you do, your entire filing process could be totally invalidated, sending you right back to square one. Section 4. Court Prep and Hearing. It is your day before the judge. Winning really comes down to preparation and evidence. You must physically bring your proof to the courthouse. Remember how you attached copies to your initial claim? Well, the judge needs to see the real deal. Bring the original signed contracts, the physical invoices, the statements of account, and the bills. Have them neatly organized in a folder so you aren't shuffling papers around. And just a quick tip on etiquette. Even though small claims is informal, treat the courtroom with total respect. Dress neatly, maybe leave the pajamas at home, speak clearly, and address the judge politely. Your organization and calm demeanor will lend incredible credibility to your pro se presentation. Something really cool happens when you arrive at the courthouse on the day of your hearing. You might not actually go straight to the judge. Maine offers a program called CADRES, the Court Alternative Dispute Resolution Service. Before a formal trial, the judge may refer you both to a free mediation session right there in the building. It usually lasts less than an hour. Honestly, it's a fantastic final opportunity to negotiate an outcome you actually have some control over. But if you still can't reach an agreement in that room, then, and only then, you proceed to the formal trial, where the judge steps in to make the final ruling. Let's move to Section 5 and see how this builds, because post-judgment actions prove that winning is really just the start. Here's the hard truth. Winning doesn't mean magical instant cash. If you win, but the defendant still stubbornly refuses to pay, you effectively become a creditor. You might need to file Form SC-003, which requests a disclosure hearing for a $30 fee. This powerful little form legally compels the debtor to appear under oath so you can investigate their financial assets, which can then lead to things like wage garnishments or property liens. On the flip side, if you lose the case, or if the defendant decides to fight their loss, either party has 30 days to file Form SC-007, a notice of appeal to the Superior Court, carrying a $120 fee. The legal journey doesn't always wrap up neatly with that first gavel strike. Wrapping things up with Section 6, Resources and Disclaimer. Let's cover our final takeaways. You absolutely do not have to memorize everything we talked about today. The Maine Judicial Branch website is going to be your best friend. You can download all those fillable forms for free and read through their incredibly comprehensive official small claims guide. The Maine Attorney General's office website is exactly where you go to initiate that free pre-filing consumer mediation we discussed earlier. And if you are a senior or qualify for legal aid, organizations like Pine Tree Legal Assistance offer excellent free resources and form guides to help you build a rock-solid case. Just a quick but important disclaimer directly from the Maine courts before we finish up. It states clearly, the specific requirements concerning your case are contained in statutes, rules, and administrative orders. Representing yourself in court can be challenging. While every effort has been made to ensure that the information presented is accurate, comprehensive, and clear, if there is any conflict between the law and this guide, the law controls. Similarly, please remember that this explainer is strictly for informational and educational purposes only and does not constitute official legal advice. Always consult a legal professional if you're unsure. And that brings us to the end of our procedural journey. We've shown you that the tools are right there waiting for you, the fees are totally manageable, and the entire system is designed for everyday people. Whether it's an unpaid debt or a ghosting landlord, you now hold the complete roadmap to justice in Maine. So the only real question left to ask is, are you ready to stop feeling powerless and finally take back what is rightfully yours? Thanks for joining me on this explainer, and good luck out there.